Hello everyone and welcome to Visa Pulse USA. If you are sponsoring a family member for a green card through the I-130 petition, then you need to watch this important update right now because major changes are coming to the family-based immigration system in January 2026, and these Trump-backed reforms could dramatically affect your case. Whether you are a U.S. citizen trying to bring your spouse, children, parents, or siblings to America, or if you are a green card holder sponsoring family members, these changes will impact processing times, eligibility requirements, and documentation standards. Some of these changes could help speed up your case, while others might create new obstacles you need to prepare for. Do not let these changes catch you off guard. Stay informed because this update will break down exactly what is changing, who will be affected, and what you need to do right now to protect your family's immigration case. Today on Visa Pulse USA, we are going to discuss the Trump-backed changes to family-based immigration, and specifically the I-130 petition process that are set to take effect in January 2026. The I-130, officially called the Petition for Alien Relative, is the foundational document that U.S. citizens and green card holders file to sponsor qualifying family members for permanent residence in the United States. This is one of the most common immigration pathways, with hundreds of thousands of petitions filed every year. The changes being implemented in 2026 represent some of the most significant reforms to family-based immigration in decades. These reforms are part of a broader immigration policy agenda that aims to prioritize certain categories of family members, increase vetting and documentation requirements, and address the massive backlogs in the system. Whether you support or oppose these changes, one thing is certain: you need to understand them thoroughly because they will directly affect your ability to reunite with your loved ones in America. So, let us dive into the details and make sure you are fully prepared for what is coming. The first major change involves the prioritization system for immediate relatives versus family preference categories. Under current law, immediate relatives of U.S. citizens, which include spouses, unmarried children under 21, and parents of U.S. citizens who are at least 21 years old, are not subject to numerical caps. This means there is no quota limiting how many immediate relative green cards can be issued each year. However, other family members fall into preference categories that have annual numerical limits, which creates backlogs that can last many years or even decades. Starting January 2026, the Trump-backed reforms are introducing a new priority processing system, even within the immediate relative category. Spouses of U.S. citizens will continue to receive the highest priority, but there will be enhanced scrutiny on marriages, especially those where the couple has been married for less than 2 years or where there is a significant age difference. USCIS will require more extensive documentation proving the bona fide nature of the marriage, including evidence of cohabitation, financial interdependence, and social recognition of the relationship. Parents of U.S. citizens will receive the second highest priority, but only if the U.S. citizen petitioner can demonstrate they have sufficient income to support their parents without relying on means-tested public benefits. The income requirement is being raised to 150% of the federal poverty guidelines, up from the current 125%. This is a significant increase that will make it harder for younger or lower-income U.S. citizens to sponsor their parents. Children of U.S. citizens will remain in the immediate relative category, but there will be stricter age-out protections and documentation requirements. The Child Status Protection Act, known as CSPA, which helps prevent children from aging out of eligibility, will be more strictly enforced, but USCIS will also be more rigorous in verifying birth certificates and parent-child relationships, especially in cases of adoption or step relationships. The second major change concerns the family preference categories and the restructuring of the priority date system. The family preference categories include F1 for unmarried sons and daughters of U.S. citizens, F2A for spouses and unmarried children under 21 of green card holders, F2B for unmarried sons and daughters over 21 of green card holders, F3 for married sons and daughters of U.S. citizens, and F4 for siblings of U.S. citizens. These categories have had backlogs ranging from several years to over 20 years, depending on the category and the country of origin. The January 2026 reforms are making several significant changes to the system. First, the F4 sibling category is being severely restricted. While it is not being eliminated entirely as some had proposed, the annual allocation for this category is being cut by 50%. This means the already extreme backlogs for siblings will become even longer. For many countries, especially those with high demand like the Philippines, Mexico, India, and China, the wait times for sibling sponsorship will likely exceed 25 to 30 years. This effectively makes the sibling category impractical for most people. Second, the F2A category for spouses and minor children of green card holders is being given increased allocation, which should help reduce backlogs in this category. This is seen as a more family-friendly reform because it recognizes that green card holders should be able to reunite with their immediate family members more quickly. Third, a new point-based system is being introduced for the family preference categories. Petitioners and beneficiaries will receive points based on factors such as the petitioner's income level, the beneficiary's education and English language proficiency, whether the beneficiary has job offers in the U.S., and whether the beneficiary has immediate family members who are U.S. citizens or green card holders. This point system will be used to determine processing order within each preference category, meaning that even if two people have the same priority date, the one with more points will be processed first. This represents a significant shift toward merit-based selection even within family immigration. The third major change involves enhanced financial requirements and affidavit of support obligations. The I-864 Affidavit of Support is the contract that sponsors sign promising to financially support their family members and prevent them from becoming public charges. Under the new rules taking effect in January 2026, the financial requirements are becoming much more stringent. The minimum income requirement is increasing from 125% to 150% of the federal poverty guidelines for most sponsors. For sponsors who have previously sponsored other immigrants and are still obligated under previous I-864 affidavits, the requirement increases to 200% of poverty guidelines. This is a dramatic increase that will make it much more difficult for middle and lower income Americans to sponsor family members. Additionally, USCIS will now require 3 years of tax returns instead of the current 1 year, and they will verify income information directly with the IRS rather than relying solely on tax documents provided by the sponsor. Asset-based sponsorship, where sponsors use savings and property value to meet income requirements, is being made more restrictive. Previously, assets could be counted at 1/5 of their value to meet income requirements, but now they must be counted at 1/8 their value, meaning you need significantly more assets to qualify. The types of acceptable assets are also being limited. Primary residences can no longer be used unless the home has equity of at least $100,000 above any mortgages, and retirement accounts like 401k and IRA can only be counted if the sponsor is already of retirement age. Joint sponsors, who are people other than the primary petitioner who agree to financially support the immigrant, will face the same enhanced requirements and will undergo more thorough vetting. USCIS is also introducing a new requirement that joint sponsors must have a qualifying relationship to either the petitioner or the beneficiary, such as being a close family member or having a documented long-term personal relationship. This closes the loophole where strangers could serve as joint sponsors. The fourth significant change relates to documentation requirements and fraud prevention measures. USCIS has announced that starting January 2026, all I-130 petitions must include significantly more supporting documentation than currently required. For marriage-based petitions, couples must now provide a minimum of 20 pieces of evidence spread across multiple categories, including joint financial documents, cohabitation evidence, social evidence, and correspondence. Previously, USCIS gave general guidance but did not specify minimum quantities. Now they are being very specific. You will need at least 5 joint financial documents, such as joint bank statements, joint credit cards, joint loans, or joint insurance policies. You will need at least 5 pieces of cohabitation evidence, such as lease agreements, utility bills, or mail showing both names at the same address. You will need at least 5 pieces of social evidence, such as photos together at family events, affidavits from friends and family who can attest to your relationship, or evidence of joint social media presence. And you will need at least 5 pieces of correspondence, such as emails, text messages, cards, or letters exchanged during your relationship. For parent-child relationships, DNA testing is now mandatory in cases where the birth certificate does not list both parents, where the child was born out of wedlock, or where there are any questions about the legitimacy of the parent-child relationship. USCIS has partnered with approved DNA testing facilities, and the cost of DNA testing, which can be several $100s, must be borne by the petitioner. For sibling relationships, additional documentation proving the parent-child relationships that create the sibling connection must be provided, including birth certificates for all siblings showing the same parent. USCIS is also implementing new fraud detection technologies, including facial recognition software to verify that photos submitted are actually of the claimed individuals, document verification systems that can detect forged or altered documents, and background check systems that cross-reference information across multiple government databases. The 5th major change involves the interview process and consular processing timelines for beneficiaries who are outside the United States and will be processing their immigrant visas through U.S. embassies and consulates abroad. There are significant changes coming. First, interviews are now mandatory for all family-based immigrant visa applicants with no exceptions or waivers. Previously, some categories, particularly spouses of U.S. citizens from certain countries, could have their interviews waived. This is no longer the case. Second, the interviews will be more intensive and will include questions not just about the relationship, but also about the beneficiary's background, travel history, financial situation, and intentions in the United States. Consular officers are being given more discretion to request additional evidence or to require second interviews if they have concerns. Third, processing times at embassies and consulates are expected to increase due to the enhanced vetting requirements. While USCIS approval of the I-130 petition is just the first step, the consular processing stage, which includes document collection, medical examination, and the interview, is likely to take several months longer than it currently does. Fourth, the medical examination requirements are being expanded. In addition to the standard medical exam, beneficiaries from certain countries will be required to undergo additional screenings, including mental health evaluations and substance abuse screening. Fifth, security clearances and background checks are being enhanced and will take longer to complete. Beneficiaries from certain countries or with certain backgrounds may face administrative processing that can last 6 months or more after their interview. The 6th change concerns conditional permanent residence and removal of conditions. When a marriage is less than 2 years old at the time the green card is approved, the foreign spouse receives a conditional green card that is valid for only 2 years. To remove the conditions and obtain a 10-year green card, the couple must jointly file Form I-751 within the 90-day period before the 2-year anniversary of receiving the conditional green card. Starting January 2026, the requirements for removing conditions are becoming much more demanding. Couples must now provide evidence covering the entire 2-year conditional period, not just evidence from around the time they file. USCIS will expect to see continuous cohabitation, ongoing financial interdependence, and sustained social integration as a couple throughout those 2 years. Interviews for I-751 petitions are becoming standard rather than exceptional. Previously, most I-751 petitions were approved without interview. But now, USCIS is interviewing a much higher percentage of couples to verify the ongoing validity of the marriage. The questions asked in these interviews will be even more detailed and personal than the initial green card interview, focusing on daily life, conflicts and resolutions, future plans, and intimate knowledge of each other. If USCIS suspects that the marriage was fraudulent or was entered solely for immigration benefits, they can initiate removal proceedings even before the I-751 is decided. This means that conditional residents are in a more vulnerable position and must be extremely careful to maintain proper documentation throughout the conditional period. The seventh major change involves public charge considerations and the expanded use of public benefits information. The public charge rule, which allows the government to deny green cards to people who are likely to become primarily dependent on government assistance, is being significantly expanded under the new regulations. Starting January 2026, USCIS will consider a much broader range of factors when making public charge determinations for family-based immigration cases. They will look not only at the beneficiary's likelihood of using public benefits, but also at whether the petitioner or their household members have used certain public benefits. If a U.S. citizen, petitioner, or their family members have received Medicaid, food stamps, housing assistance, or other means-tested benefits within the past 3 years, this will count against the petition and may require a higher income showing or additional evidence that the beneficiary will not become a public charge. The types of public benefits that count against you are being expanded to include not just cash assistance, but also certain healthcare programs, nutritional assistance, housing subsidies, and even some tax credits. Exceptions exist for certain benefits such as emergency medical care, disaster relief, and benefits received by children. But the list of countable benefits is much longer than before. The health insurance requirement is also being strengthened. Petitioners must show that they have health insurance for themselves and their household members and must commit to obtaining health insurance for the beneficiary within 30 days of their arrival in the United States. Failure to maintain health insurance can be grounds for denying the removal of conditions on a conditional green card. The eighth change pertains to employment authorization and work permits for pending adjustment of status applicants. When a family member is in the United States and files to adjust status to permanent residence based on an approved I-130, they can also apply for an employment authorization document, or EAD, which allows them to work legally while their green card application is pending. Under the new rules starting January 2026, there are important changes to this process. First, the automatic extension of EADs that are expiring while a renewal is pending is being limited. Previously, if you filed a timely renewal application, your EAD would be automatically extended for up to 180 days. Now, the automatic extension is being reduced to 90 days, and certain categories of applicants will not receive automatic extensions at all. Second, USCIS is implementing more stringent background checks before issuing EADs, which is likely to increase processing times. Third, EAD applications are being subjected to in-person biometrics appointments at application support centers, even for applicants who have recently provided biometrics for other applications. This creates additional time and logistical burdens. Fourth, the fee for EAD applications is increasing from $410 to $550, making it more expensive to maintain work authorization while waiting for a green card. The ninth significant change involves country-specific caps and per-country limitations. Currently, no single country can receive more than 7% of the total family preference visa numbers available each year. This creates massive backlogs for high-demand countries like Mexico, the Philippines, India, and China. The January 2026 reforms are not eliminating per-country caps as many advocates have hoped, but they are introducing a new system of rolling caps that will slightly reduce disparities between countries. Under this system, if a country has not used its full allocation in a particular preference category for 2 consecutive years, those unused numbers will be redistributed to countries with backlogs. While this may provide some minor relief, it does not fundamentally solve the problem of decades-long wait times for certain countries and categories. Additionally, USCIS is implementing a new country risk assessment system that will subject applicants from certain countries to additional security screenings and documentation requirements. The list of countries subject to enhanced scrutiny includes not only the traditional countries of concern, but also any country that has had high rates of visa fraud or immigration violations in the past 5 years. The 10th and final major change concerns appeals, motions, and administrative remedies. When an I-130 petition is denied, or when there are issues with the case, applicants have the right to file appeals or motions to reconsider. Starting January 2026, the procedures and timelines for these remedies are changing. First, the time to file an appeal is being reduced from 33 days to 21 days from the date of the denial notice. This shorter time frame means applicants must act more quickly when they receive unfavorable decisions. Second, the fees for appeals are increasing significantly from $675 to $1,000 for most cases. Third, the Administrative Appeals Office, or AAO, which handles these appeals, is implementing stricter standards for accepting new evidence that was not submitted with the original petition. Previously, the AAO would often consider new evidence even if it was not submitted initially, but now they will only consider new evidence in very limited circumstances. Fourth, the time frame for the AAO to decide appeals is being extended from the current goal of 180 days to up to 365 days, meaning you may wait a full year or more for an appeal decision. Fifth, for cases involving consular processing where the visa was denied under Section 221G for administrative processing or under Section 212A for inadmissibility, the options for challenging these decisions are being further limited, with fewer cases qualifying for review by the Board of Immigration Appeals. Beyond these 10 major changes, there are numerous other smaller but still important modifications to the family-based immigration system. The USCIS website and online filing systems are being updated to require electronic filing for most I-130 petitions, with paper filing only allowed in exceptional circumstances. The forms themselves are being revised with more detailed questions and additional sections. Processing fees are increasing across the board, with the I-130 filing fee rising from $535 to $710. Biometric fees are being added for petitioners in certain circumstances where they were previously waived. The required supporting documents must now be submitted in specific formats, with specific labeling and organization, and failure to follow the detailed formatting requirements can result in rejection of the entire petition. So, these are the comprehensive Trump-backed changes to the family-based I-130 immigration process that are coming in January 2026. These changes represent a fundamental shift in how family-based immigration works in the United States, with increased emphasis on financial capacity, enhanced vetting and documentation, stricter fraud prevention, and longer processing times. Some of these changes may have positive effects, such as reduced backlogs in certain categories, while others will create new challenges and obstacles for families trying to reunite. Regardless of your views on these changes, the reality is that they are coming, and you need to prepare. The strong recommendation from VisaPulse USA is that if you are planning to file an I-130 petition, or if you have a petition currently pending, you should consult with a qualified immigration attorney who can help you navigate these new requirements. Immigration law is complex, and these changes make it even more so. Trying to handle your case without professional help could result in delays, denials, or even jeopardizing your immigration status. This update on VisaPulse USA has provided a comprehensive understanding of what is changing with family-based immigration in January 2026 and how these Trump-backed reforms will affect I-130 petitions. Stay informed with VisaPulse USA for the latest developments in U.S. immigration law and policy. We are committed to providing accurate, detailed, and timely information that helps you make informed decisions about your immigration journey. Share this update with anyone you know who is going through the family-based immigration process, or who is planning to sponsor family members, because this information is absolutely critical for anyone involved in I-130 petitions. Thank you for watching VisaPulse USA. Stay informed, stay prepared, and we wish you the very best in your immigration journey. Take care, and we will see you in the next update.